Welcome to our March 2023 edition of This Month in Payroll. I'm Rowan Geddes, National Leader of PwC's Payroll Advisory Practice. And in this month's edition, we will explore the latest instalment of the Jamsec case, this time regarding the extended definition of employee for superannuation guarantee purposes. We will explore the introduction of overtime entitlements and record-keeping obligations into the Professionals Award, covering engineers, scientists, and IT professionals. We'll look at changes to the government's paid parental leave scheme and review a few payroll-related cases in play at the moment. But first, the latest instalment of Jamsec. Last year, two High Court decisions, Jamsec and Personal Contracting, were handed down which significantly altered the landscape for the employee versus contractor test by introducing a greater focus onto the wording of the contract, rather than relying on the long-held facts and circumstances test. The High Court decision focused on the definition of employee under the Fair Work Act. However, there was a second element to the Jamsec case. In the original federal court case, the plaintiffs, two drivers, also argued that they were employees under the extended definition of employee within the Superannuation Guarantee Act. However, this argument was not entertained by the federal court because the drivers had been engaged through their partnership rather than as individual workers, and so were not a party to the contract in any way. The decision was appealed to the High Court, but the High Court declined to rule on the SG question. Instead, it reverted the case back to the full federal court to allow the tax commissioners to join in, given the significant revenue consequences. The key argument put forward by the Drivers' Council was that to be an employee under a contract, all that a person requires is that there should be a contract, which is wholly or principally for the labour of a person, and that the person must work under that contract. Council then argued that a partnership is not a separate legal entity, and that Section 12.3 of the SGAA simply requires that a person works under a contract, not that the person was himself a party to the contract. Note that the Commissioner did not agree with this, submitting that Section 12.3 only has application where the employee is an identified natural person who is a party to the contract in their individual capacity, rather than in any other capacity, such as a partner or a trustee of a personal services trust. This view was accepted by the court, who found that Section 12.3 of the SGAA only operates where an identified natural person, the worker, is a party to a contract in their individual capacity, that worker works under the contract, and the principal on the other side of the contract makes payments to the worker in respect of their labour. The result of the Jamsec appeal is no change to the current position. However, it does provide an affirmation of a key point, that SG can only apply in a situation where the worker, a natural person, is a party to a contract in their individual capacity. For entities that engage contractors, it reiterates that best practice is to engage contractors via a written contract through an interposed entity. This will provide clarity around responsibility for employment obligations such as SG and PAYG withholding. Engaging a contractor as an individual may result in the contractor attracting SG if the contract is for the provision of labour. Changes to the Professionals Award, including capturing of hours. Historically, employees covered under the Professional Employees Award were not entitled to additional payment for overtime hours, and accordingly, employers were not required to track time. This month, the Fair Work Commission released its determination to vary the Professional Employees Award, bringing in overtime and penalty rates and introducing a new level of time-sheeting requirements for industries which are historically highly flexible. The Professional Employees Award covers any employee performing professional engineering, scientific or IT duties or quality auditing, provided that the employee is not employed in a managerial position. Under these changes, any non-management employees, provided they are not paid more than 25% above the appropriate minimum annual wage rate, will become entitled to the following from the 16th of September. 1. Paid overtime or time off in lieu if the employee works more than 38 hours in a week. 2. Penalty rates for working unsocial hours, being a penalty rate of 125% for work before 6 a.m. or after 10 p.m. from Monday to Saturday, and a penalty rate of 150% for work on a Sunday or a public holiday. To facilitate these changes, employers will be required to keep records of hours worked by employees that are in excess of 38 hours per week, worked before 6 a.m. or after 10 p.m. between Monday to Saturday, or worked on a Sunday or a public holiday. These changes to the Professional Employees Award align the award with many other modern awards, and the introduction of timesheeting requirements is something that employers in similar industries, such as legal and banking, have had to deal with for the last few years. Learning from these experiences, the introduction under this award is likely to present significant changes. Employers with employees covered by this award should review their current remuneration schedules for affected employees to consider the impact of the new overtime and penalty rules on total remuneration, develop processes to capture and store time records, and undertake a comprehensive change program to explain to employees the change to capturing time. If not handled well, the introduction of timesheeting can drive trust issues within the workforce. And check if employment contracts contain a comprehensive contractual set-off clause, and if these clauses can in fact be relied on, given that set-off is such a hot topic with the Ombudsman at the moment. Changes to the government's paid parental leave scheme. This month, the Paid Parental Leave Amendment Bill passed both houses, bringing in changes designed to make the paid parental leave scheme more flexible and gender neutral. With these amendments, parents whose babies were born or adopted from July 2023 will now be entitled to an additional 2 weeks of parental leave pay, increasing from 18 weeks to 20 weeks between them. This entitlement will increase by 2 weeks each year over the next 4 years until it reaches a total entitlement of 26 weeks leave by July 2026. Secondly, the distinction between primary, secondary or tertiary claimants will be removed, allowing families to decide who will claim the entitlement first and how they will share the entitlement. Third, the requirement to not return to work has also been removed. And fourth, paid parental leave can now be claimed in multiple blocks within 2 years of the birth or adoption of the child. In addition, the income test is now broadened so that if an eligible parent's income is over the single income limit of currently $156,647, they can still be eligible, provided their combined family income is less than $350,000. Parents still must have been employed by an employer for at least 12 months before the expected date of birth or adoption, and they must continue to be employed while receiving their parental pay. Finally, there are a few cases in play at the moment which are about payroll in general, rather than affecting payroll. First, and possibly most significantly, is the fact that reasonable overtime is being tested in the courts at the moment. The Fair Work Act provides that an employer must not request or require a full-time employee to work more than 38 hours in a week unless the additional hours are reasonable, and an employee has the right to refuse to work those additional hours if they are unreasonable. Whether additional hours of work are reasonable has long been a subjective question. This issue is now before the courts, and it has already been receiving media attention through the case of independent MP Monique Ryan, who is being sued by her former Chief of Staff, Sally Rugg. Ms Rugg was terminated for refusing to work unreasonable additional hours. However, a case more relevant to our audience was launched this month when the Finance Sector Union launched a test case in the Federal Court against NAB, asking the court to make a determination on what constitutes reasonable overtime. The case is expected to test for the first time what reasonable additional hours are for white-collar workers and could have significant ramifications not just for NAB, but for other banks and professional firms across the economy. The second case is a request to the High Court to hear a constitutional challenge to Victoria's wage theft laws. The case has been launched by the owners of the Macedon Lounge, who have been hit with 47 charges under the Victorian Wage Theft Act. In response to these charges, the owners are arguing that the provision under which the nation's first criminal prosecution was launched are invalid on the basis that the Constitution says that valid federal laws prevail over inconsistent state laws. They argue that national employers in Victoria are currently subject to 2 systems of administration, inspection and enforcement of terms and conditions conferred by the Fair Work Act, in circumstances where the Constitution demands that this must not be so. The owners also argue that because Victoria's Wage Theft Act creates a system of criminal punishment for the enforcement of federal laws, it is inconsistent with the Fair Work Act, which does not currently contain such notions of criminality. Note that the Australian government has committed to introducing a criminal offence for wage underpayment in the near future. We will watch this application with interest. At this stage, we do not know whether the High Court will even agree to hear the case. However, other states, such as Queensland, also have their own wage theft laws. So this case, if heard, could have broad ramifications. Finally, we can't finish this month in payroll without recognising that the Plutus payroll fraudsters were all found guilty this month of running an audacious, as in how did they ever think they'd get away with it, tax fraud scheme. The 5 accused, led by Adam Cranston, set up a free outsourced payroll offering, Plutus Payroll, and then proceeded to not remit PAYG withholding tax and GST to the tax office, to the tune of $105 million. This scheme was facilitated through a series of shell companies which held the tax debt, with vulnerable people installed as straw directors. The companies were then liquidated and replaced with new companies whenever a debt was pursued. This fraud all occurred in the days before single touch payroll, and the real-time reporting that STP facilitates should now prevent this from ever happening again. It was, however, built on the basis of a payroll offering which was provided to users for free, which goes to prove the old adage, if it looks too good to be true, it probably is. Adam Cranston and his co-conspirators will return to court in early May for sentencing. And that's it for this month in payroll. If you would like to revisit any of our prior updates, they are available on our website at pwc.com.au/payroll. And if you have any questions or need for support, please reach out to myself or your usual PwC contact. Until next time, have a great month in payroll.